This lecture discusses some of the matters covered in Chapter 7 of the textbook, which deals with tort law. Now we're transitioning from discussions of procedural matters of law to actual substantive legal matters. And you'll recall from our past studies the difference between substantive law and procedural law. Chapter 7 again deals with tort law. Just by way of warning, this one chapter covers what is an entire year's class in a first year of law school. So this is just a brief overview of some of the concepts that are associated with tort law and some specific torts that are commonly seen in the legal system. But it's by no means a complete discussion of tort. Again, that's far beyond the scope of this class. Torts, it's important to distinguish torts from criminal law. Both of them deal with wrongs, and specifically wrongs committed by one person or one company, but the difference is in the focus of who the victim is. In tort law, we focus on the recovering damages for the person that was actually harmed by the wrong. And hence, we call torts a private wrong. We contrast that with criminal law, where society is actually the offended party. We've discussed this a little bit in the past. You remember there's some types of crimes that we would consider to be victimless crimes, where nobody was really hurt by the crime, but nevertheless, the conduct has been deemed to be criminal by society, by our legislature. On the other hand, torts, again, focuses on recovering damages for the party that was actually injured. Some acts can be both torts and crimes, again, depending on whether or not the legislature has deemed the conduct to be criminal. The easiest example of that is a battery. If I were to pick up a baseball bat and chase after you and beat you with the baseball bat, that is civil battery. You would have the right to sue me for the battery, for the damage you suffered. It is also criminal battery, and I could be criminally prosecuted for the actions. So again, same act being both a crime and a tort. We just break down tort law into two basic types: intentional torts and negligent torts. And it's important to understand, the textbook makes this clear, that there is no such tort called intentional torts. Again, it's just a category of torts that focuses on the state of mind of the person that actually commits the wrongful act. So again, that's an intentional tort. We contrast that with negligent torts that we'll discuss in a few minutes. It's easy to kind of lose focus of what we're discussing, and the cases that are outlined in the textbook provide excellent fact patterns that allow us to analyze the different types of torts that are involved. Case number 8 at page 182 of the textbook discusses injuries suffered by a person who was involved in a recreational softball game. And the questions, whether or not the person that is harmed in that softball game, do they have a legitimate cause of action against any of the other participants in the softball game? Again, it's important to keep these fact patterns in mind, so we can so we can actually focus on the torts. The first type of intentional tort that's discussed in the textbook is assault. And assault is, again, one of these intentional torts that involves a certain state of mind of the tortfeasor, the person that commits the torts. And the three elements of an assault are an intentional act, the second element that creates a reasonable apprehension, and the third element is an immediate harmful or offensive physical conduct. So assault, unlike battery, doesn't actually require actual conduct. If I swung a baseball bat at you and missed, I would not have committed a battery if I didn't hit you, but I have committed an assault. I committed an intentional act that created a reasonable apprehension of immediate harmful or offensive physical conduct. Battery, on the other hand, another way to look at it is it's the actual completion of an assault. So the elements of a battery, an intentional act that creates a harmful or offensive physical conduct, and that happens immediately. So again, swinging the baseball bat and hitting you with it amounts to a battery. Oftentimes we have both assault and battery involved in the same crime. So in most instances, a battery also includes an assault. The only time that you really would have a battery where you didn't have an assault if someone struck somebody just out of nowhere where the victim didn't have any notice that it was the striking was going to happen. Again, both of these are intentional torts. One of the hallmarks of an intentional tort, or one of the reasons that they're so important, is that with that intent comes the possibility of recovering punitive damages from the tortfeasor. And again, we use the term tortfeasor to refer to the person that committed the act. Punitive damages generally are not allowed in negligent tort actions. We'll talk about that in a moment. A good fact pattern presented in the textbook that involves several intentional torts is case number 9 of the abused spouse. It appears at page 184 of the textbook. And this involves a situation where there's obvious spousal abuse, both physical and mental. Coupled with that were reckless statements and intentional statements that were made by a husband regarding the conduct of his wife, and specifically statements that were made to the wife's employer about the fact that she allegedly was embezzling money. And finally, there's an element of just plain out cruelty, where the husband tells the wife that her mother had suffered a massive heart attack when in fact she hadn't. So this fact pattern, again, it's important to read that fact pattern carefully, involves elements of several intentional torts. And it's up to you to analyze what torts were actually involved. Was there an assault? Was there a battery? Were there other intentional torts that might apply? Some of the other intentional torts that are discussed in the textbook include false imprisonment. False imprisonment, again, is illustrated by the slide, can best be illustrated by someone being detained for allegedly shoplifting when they actually did not shoplift. So if a security guard at a department store takes somebody into custody, confines them through force, and if it's unreasonable, the security guard and their employer could be sued for the tort of false imprisonment. And again, the question with false imprisonment is what is reasonable? What amount of force is reasonable? How long of a detention period is reasonable? These would be defenses, obviously, put up by a department store. There's a good discussion of some of the issues presented in false imprisonment cases at page 187 of the textbook. The text also discusses the tort of defamation, and defamation is alive and well. Defamation involves several elements, three basic elements. One is a publication of false statements that cause harm to reputation. So publication is somewhat self-explanatory. What it means is that someone is putting out for public purposes allegedly false statements about, or certainly false statements about someone. If two people are talking together and one person says to the other false statements about that person, that is not defamation because there's no publication. They haven't communicated that to any third party. Again, the publication is putting it out into the public domain. And again, if it's a false statement, that causes a harm to reputation. So when we're analyzing the tort of defamation and the damages that might be suffered, people want to know how extensive was the publication, how many people found out, how bad was the false statement, what type of allegation, and again, trying to measure some kind of harm to the reputation. Defamation is broken down into two separate categories: libel, which is written defamation, and slander, which is oral defamation. The most prominent defense to a defamation claim is its truth. So again, you could have a publication of a statement that causes harm to someone's reputation, but if it's a true statement, it is not defamatory. So, but by definition, it is not defamation. There are other privileges to defamation actions that are not discussed in the textbook. One of them is a privilege that's associated with legal actions. So if someone makes a defamatory statement in the course of a legal proceeding, whether it's in a written brief or an oral argument before the court or in testimony, there's an absolute privilege that's associated with that. Again, there's defamation, as I said, is alive and well, and remains a hot topic. The text talks about defamation claims against public figures, and this was set forth in the famous U.S. Supreme Court case of New York Times versus Sullivan, where the New York Times newspaper was sued for defamation. That court case stands for the proposition that in order for a public figure to recover damages for defamation, they also have to prove that the statement was made with actual malice. So we have an additional element that is present when public figures are involved, and malice. It's kind of a slippery element, but what it means in the context of defamation is that the defendant either knew the material was false but went ahead and published it anyway, acted with reckless disregard for whether or not the statement what was true. So again, very, very difficult for a public figure to recover damages for defamation. There are other intentional torts that are discussed in the textbook that I'm not going to be covering in the lecture. And again, it's important for you to review those. These include invasion of privacy, intentional infliction of emotional distress. Other intentional torts include those that involve damages to somebody's property. And these are described in the textbook. They include trespass to land, trespass to personal property, meaning detaining personal property, and conversion of personal property. Conversion of personal property is simply theft. So again, if I were to steal your laptop computer, that's a tort of conversion, and you would have the right to sue me for the damages you suffered. It also happens to be a crime that could be prosecuted by the state. Okay, the other intentional torts that are not covered in detail in the textbook, but described, include false arrests, malicious prosecution, bringing of lawsuits without cause, abusive processes related to that, fraud cases, misrepresentation, interference with contractual relationships. Again, there are many, many, many torts, and as I said, the textbook just kind of scratches the surface and introduces you to them. The other primary category or classification of torts are negligent torts. And again, as far as our legal system, there are far more negligent torts brought before the courts than intentional torts. You think of a slip and fall in a supermarket or an auto accident. These are typically brought as negligent actions and not as intentional torts. Again, negligence is a classification of a tort. It's a type of tort, but there is no such tort called negligence. The negligent conduct has to be associated with some other type of action, of conduct. The elements of negligence, there's 4 of them that are included in every negligent cause of action. And one is the defendant owed some sort of duty to the plaintiff to act reasonably. Second, that the defendant breached that duty. In other words, they did not act reasonably, and that there was causation of the plaintiff's harm by the defendant's conduct. And again, we have these elements that are present in every negligence action. The duty of care aspect, sometimes we have a situation where a third party may be injured as a result of conduct by a tortfeasor that is not reasonably foreseeable, or not, I shouldn't say reasonably foreseeable, not imminently evident. And the examples that the text gives of this are where somebody serves alcohol or drugs to somebody, and that person then in turn injures a third party. Dram shop acts are taken an Old English term, a dram shop being a tavern or something. And a dram shop act is a statute that imposes liability on a restaurant or a bar that serves alcohol to people that are obviously intoxicated, who then go out and injure someone else. social host liability extends that liability to someone that serves alcohol at a private event, such as a party or something like that. If you hold a party and you allow alcohol to be served to people that are obviously intoxicated, and they go out and then hurt somebody as a result of that, again, the person that provided that alcohol can be sued. The common element of any negligence action is whether or not the conduct was actually reasonable or not. So again, if we focus on these dram shop acts or the social liability doctrines, the idea is that it is not reasonable to serve alcohol to people that are obviously intoxicated, and that it's reasonably foreseeable that that person could harm someone else. So again, we find there a duty of care. Again, the first element of tort breached, again to some third party. One of the elements of negligence that is extensively discussed in law school is the causation element. Let me go back to the first slide. And what this brings up is the idea that not all negligent acts give rise to a valid legal claim. And this was really illustrated most clearly in the case of Palsgraf versus Long Island Railroad Company. There's a discussion of the Palsgraf case at pages 195 and 196 of the textbook. And I also, in the modules, put up a short video that illustrates the Palsgraf, what happened in the Palsgraf case, and contains a discussion of what happened. So in the Palsgraf case, Mrs. Palsgraf was a plaintiff. She was standing on a railroad platform, waiting for a train to arrive. On another train track, again, not even her train track, so a man was running and trying to get onto to catch a train that had just started to move. A guard pushed him from behind, and the man, he got on the train, but he dropped his package. And contained in the package were fireworks. The fireworks exploded, and the explosion caused a scale to tip over, and that scale struck Mrs. Palsgraf, seriously injuring her. And so here we have a situation where the negligent conduct of or the allegedly negligent conduct of the railroad, being the pushing of the passenger, really was a cause, and in fact, it caused damages to Mrs. Palsgraf. If it had not been for that conduct, she would have never been injured. But the issue in that is, how remote that conduct was, and is it the type of conduct that is going to give rise to liability. And what the Palsgraf case stands for is that there's a foreseeability element to negligent cases. So again, if the injury is so remote and and totally unforeseeable, you're not going to have there is not a valid legal claim. There's a good question or discussion of that at page 196 of the textbook, where I'm just going to read the fact pattern. A chauffeur negligently collides with another car that is filled with dynamite. And although he didn't know it, that car exploded. A, walking on the sidewalk nearby is killed. B, sitting in a window of a building opposite to that is cut by flying glass. C, sitting in a window a block away is injured. And last, a nursemaid 10 blocks away was startled by the sound of the explosion and dropped a baby from her arms to the sidewalk. And again, this kind of illustrates that, the collision and the explosion were caused, by negligent conduct of the chauffeur. But which one of these people are we going to allow to have valid claims? Again, we have to. There's an element of foreseeability involved, and one could argue that none of them had valid claims. That it's not reasonable to anticipate that someone would be carrying dynamite in the trunk of their car. Again, these are things that lawyers argue about. So, but a defense lawyer would certainly argue that none of those people had a valid claim because it's simply not foreseeable. Again, I'm not attempting to answer that question. These are subjects of law school examination, essay questions that and bar exam questions that people are required to fill out. There are various defenses to negligence that are discussed in the textbook. Again, they're outlined on the slide here. The most important defenses are comparative negligence and assumption of the risk. Comparative negligence involves comparing the negligence of the plaintiff and the defendant and allocating liability based upon comparative negligence. So with comparative negligence, we determine what percentage of the accident or the incident is attributable to the plaintiff, what percentage is attributable to the defendant, and we apportion the liability. So if it's an automobile accident case and someone is rear-ended under the comparative negligence doctrine, the person that rear ends certainly has some liability because they were following too closely. However, it's possible to argue that the person stopped for no reason, just out of nowhere, and that they're somewhat partially responsible for their damages. So again, we try to we measure that. And under most states' laws, if a plaintiff is more than 50% at fault, they cannot recover. That's the law in most states. If they're 49% negligence, they do have a claim, but it's going to be offset, and their damages are going to be offset to the extent that they're at fault. Assumption of the risk means exactly what it says, that the plaintiff engaged in some kind of conduct whereby they assumed the risk of damages. So if someone's participating in a sporting event and is injured, the defendant may argue that the injuries suffered were reasonably foreseeable, and the plaintiff, in engaging in that conduct, assumed the risk. Closely related to the assumption of the risk document or doctrine is where there's a waiver involved. And this comes up, for instance, if somebody, again, participates in a sports league or something like that, they're generally required to sign some kind of document acknowledging that they're assuming the risk of injuries associated with that. And so again, along with the assumption of the risk, we have a written waiver. Another example of something of the risk doctrine would be somebody going to a baseball game and sitting in the audience and being struck by a foul ball, or a home run, for that matter. When you buy a ticket, part of your contract of buying a ticket to a Major League Baseball game is you're acknowledging and waiving, you're acknowledging the risks and waiving any claims. But again, this is an element of assumption of risk. Finally, there are various immunities that are discussed in the textbook, including sovereign immunity and various impediments to filing claims against the government. All right, I'm going to conclude with a discussion of remedies. Again, the goal of tort law is to damage or to compensate the plaintiff for the damages that they suffered, and those types of damages we call compensatory damages. They are damages that make a plaintiff whole, or attempt to make a plaintiff whole. So, for example, if someone is injured in an automobile accident, and a result of that automobile accident, they are unable to work, an element of compensatory damages is compensating them for their lost wages. Other elements of compensatory damages in that case would reimbursing them for the medical bills that they incurred in connection with the accident, and in addition, the pain and compensating them for the pain and suffering that they incurred as a result of the incident. Medical bills, lost wages, these are relatively easy to measure. If it's a young person, it's a little bit more difficult to measure what their lost wages would be, because if it's a permanent condition, you then have to speculate as to what type of career they would be involved in, and try to measure the damages based on that. The pain and suffering damages, these are difficult to quantify, and in most cases are one of the main elements of a claim for personal injuries. And attorneys can get very creative in arguing for those pain and suffering damages. But again, all of these are elements of compensatory damages. Punitive damages, on the other hand, are not necessarily related to the harm that was suffered by the victim, but instead are imposed on the tortfeasor by way of punishment. So punitive damages are not designed to compensate the victim, but rather to punish the wrongdoer. Punitive damages are only available in intentional tort cases. They're not available for negligent actions unless the negligence was so reckless to be all but intentional. And punitive damages are not available in breach of contract cases. So again, important to keep that in mind. So again, these the compensatory and punitive damages are the main types of damages that are involved. All right, this has just been a brief overview of the materials in Chapter 7. Again, I expect you to review the entire chapter and be familiar with all of the topics discussed in the chapter, including those ones that were not covered in the lecture.